Good day and welcome to today's legal masterclass for startups and small businesses. I hope that you'll enjoy the session with us today. My name is Nicolene and I will be your presenter today. I'm an attorney, conveyancer, notary public and mediator, as well as an internationally accredited legal project practitioner. I practice as such at Schoeman Law Incorporated, based in Cape Town, South Africa. But today, I'm here in my capacity as one of the skilled facilitators at Pocket Advisor, and I'm looking forward to taking you through the legal material for the day. Please note that these slides, as well as the presentation I will be taking you through today, are copyright protected. Any unauthorized distribution is therefore strictly prohibited. We're sharing with you today in good faith and ask that you respect that. In terms of our overview, let me get straight into what you can expect now that we have all the formalities behind us. First and foremost, I want you to see what we are going to be unpacking today as a journey through the structure that you've put in place or maybe are planning to put in place, how we negotiate or interact with those that we know we need cooperation from or assistance from in order to build our business. We are going to be looking at some key relationships, the people that make the wheel turn round. We'll look at some sound decision-making mechanisms and legal provisions and how to package your business and to set it up for growth and scale. At Pocket Advisor, we realize that business failure is a serious problem in South Africa. The top reasons for business failure include no access to funding opportunities, issues when entering big business supply chains, legal disputes resulting from no or inadequate contracts, and the reputational damage from unhappy customers venting their unhappiness online. The good news is that Pocket Advisor addresses all these issues. In many ways, structuring your business and the relationships surrounding it most effectively to position yourself for growth, for scaling, and ultimately for success can be compared to the construction of a building. Now bear with me. Today I want you to keep in your mind's eye that we are constructing a building, your business being the building. Now, the foundations are quite essentially the one feature that, if flawed, everything that comes thereafter will similarly be flawed. Now again, if we look at the walls, the windows, the structures, and ultimately the roof, how does this relate to our business? Fundamentally, we need to pick the most suitable structure. In other words, a juristic entity, such as a company or a few years ago, a closed corporation. These days, those do not exist any longer. So let's just reference a company structure. The company structure, by virtue of its registration, will also involve setting up a company constitution or MOI, and later on other agreements directing core relationships on an ownership as well as a management level. And this leads to everything else that flows into constructing your building. For example, a shareholders agreement and even policies dealing with decision making on board level can often be seen as the weight-bearing walls to keep your building upright. Sound and ethical decision making is crucial. And of course, all the fittings that fill the gaps and protect the building's inside from the outside elements, being those relationships that not only keep you safe, but keep you growing, keep you expanding, and ensure that you do so. And ultimately, the roof that we construct can also be compared to our core relationships and even our provisions in relation to the limitation of risk, for example, insurance and so on, to keep us and everything that we've worked for safe. Later in your journey, that could even be your will. And your will is basically a document that will protect everything that you've spent your life building and working towards, so that you leave a legacy and an imprint. So ultimately, starting with our foundations has to lead us ultimately to constructing a roof, so that we are able to imprint and leave a legacy in the business that we have constructed, as well as our communities. Now, even before we actually reach the point of foundation, of construction of this building, this business that we are aiming to build, we actually need to forge strategic relationships first, which means we have to negotiate. So one of the first points is really negotiating effectively. That's actually the first point of departure before we even consider digging a foundation, proverbially speaking. Now, before we go into any negotiation, I always recommend to entrepreneurs to be very clear on a couple of things. What do you aim to achieve? What do you want to see as the outcome of these interactions? What are your priorities? What is critically important and time-bound for you to achieve? What do you need to achieve first? And are there any areas on which you can compromise, or are there any trade-offs? Now, in the textbook by Pienaar and Spoelstra on negotiation, they speak of an aspiration base versus a real base, which is basically illustrated by the diagram at the top of your screen. Now, basically, we all start as sellers, or when we do proposals, with almost an unrealistic high expectation in many instances. And often, completely the polar opposite, our buyer is looking for a bargain, in simple words, in simple terms. They are looking for offering much less than what is on offer from the seller's perspective. And that means by the way we speak and how we present ourselves, we are actually very far apart. But truth be told, when people are honestly wanting to negotiate with you, forge a relationship, enter into a transaction, there's a place that they call the real base, the reality of what you know as a seller in your heart of hearts is actually more realistic to expect. And what you know in your heart of hearts as a purchaser is more realistic to be paying. And if you see the example of a sale of a motor vehicle on the screen, you'll see that there's quite a substantial difference. So the point is really getting the person who you are speaking to operate in that real base. Or if you see there's no way in getting that person there, to know that early on enough so that you don't waste resources on trying to forge a relationship with someone who's bargaining with you, not negotiating. Now, adding on from that, planning in any negotiation will make or break your efforts. And I find often we are negotiating extremely important relationships, yet we are ill prepared when we go into those discussions. We have not anticipated our customers' questions around our proposal, for example. We have not anticipated what our potential investor is wanting to know about us. We don't prepare in many instances at all. So I think a couple of points from my project management background. It is important for us to stay clear to the course. What exactly are we aiming to do? What have we been tasked to do? What are we proposing? And what I mean by that is, have we answered a call, perhaps a tender or a RFP or RFQ, and have we understood the scope of what the tenderer wants adequately? Have we identified what our business is all about, what our capacity looks like, and how much money we need from an investor, and if we get it, what we'll do with it, and how do we ensure that the investment reaps benefits to our investor in the case of a proposal or a call for investment funding. So be clear on what we're doing, the scope. Break it down into tasks, activities, and milestones. Particularly important to measure the milestones against metrics. For example, in our call for investment, if we get X amount of money, we are going to utilize it like this, and we anticipate that as an outcome. Maybe an increase in revenue, an increase in production. But tie it to something that is measurable and tie it to time. So the what, how we measure, and when we anticipate it to be measured, etc. Crucially important. What do we need in order to achieve this? Whose responsibility is what? You need to know what your estimated costs are going to be. Are you going to have to buy some material, or maybe hire machinery, or buy more machinery? You will need to know in your context if it's going to cost you money, and if so, whether you have enough of it. Particularly important in a client proposal context. And then, of course, if there's a budget communicated to you, perhaps from a client, or there's a limitation on the potential funding budget in this context, you need to know whether what you are wanting to do and achieve is doable within that budget or constraint. Beyond the planning issue that I dealt with in the previous slide, the other thing that I think we often miss as entrepreneurs is really knowing what is at stake and what we want to achieve, particularly in our first or second round of discussions. And what happens if the outcome we are seeking to achieve doesn't work out that way? So, for example, is this a win-win or a win-lose situation? And this is usually particularly relevant when something has become a little acrimonious. So in that context, potentially, let's say, an unhappy customer. Is the only way to solve this that someone feels they've won and the other person feels they've lost? Or are you putting something forward that makes everyone walk away having benefited? That's really important to know from the outset. What is at stake and what's the reality of our situation? Is this a relationship, particularly in a more tricky situation, that you're trying to negotiate yourself out of, that can potentially damage your business if it ends? Do you need it? Is it a customer that you can afford to lose? Can you replace that customer, for example? When you meet, it's important to see if the other person is acting for themselves or if they've hired a lawyer, for example. Who is the person representing the other side? What do you want to achieve in the first meeting? You need to at least have one goal in your first meeting, follow-up meeting, second goal. Otherwise, that's when we have meetings where we feel, oh goodness, that was just a giant waste of time. And what is going to happen if our negotiation attempt fails? If we don't reach an agreement at this meeting, what then? Particularly when a relationship, I think, stands on the brink of collapse. When you lose that customer, when you cannot find a compromise, what is going to happen? It could even potentially mean that we go to court. But we need to know these things as we have the conversations. Let's talk about issues. In project management, we speak of risks and we speak of issues. Now, risks in a project management scenario is something that you can foresee can potentially happen. It could be likely, could be very likely or extremely likely, or it could be extremely unlikely from occurring. The point is you need to know about them and to plan to avoid them. However, if a risk is unidentified and unaddressed, it becomes an issue. So in a negotiation, it would be good for you to sort of map out worst case scenario. What could they say? What could they ask? What happens if they do this? What happens if they expect that? So issues can be simple, they can be complicated, can be even subtle. So you really need to jot down before you have the conversation, what are some of your worst case scenarios? What can we do about them? Why would this be an issue or a risk or a problem raised by the other person? And what do they need? What do they want to avoid potentially by raising it? Now, once we have compromised, agreed, or navigated these issues, we need to contract. So in the next slide, we'll bring it all together. But once we've had these discussions and we've reached agreement, the next step is to solidify it legally. Now, in order to reach a valid agreement, in other words, to conclude your discussions and negotiations, you need to have a meeting of the minds on all matters, including your potential risks or issues. The person who you are sitting with must have the authority or the capacity to agree with you. There's no use in reaching an agreement with the personal assistant to the CEO. You need to reach an agreement with the CEO. Whatever we agree needs to be realistic and possible. It needs to be legal. And some agreements need to take a particular form. For example, contracts to buy property must be in writing. Loan agreements or financing agreements must, at this point in time, be signed, generally speaking, physically, it cannot be signed electronically. Just to name two examples for you. So we need to know if we navigate issues, the analyses of what could potentially happen here and what's the type of situation I'm walking into, and all the terms, conditions, and obligations, we need to make sure that those 5 components, consensus, capacity, possibility, legality, and formalities, are all met in order for us to seal a valid contract. So to sum up, before we go on with more relationships, you need to follow the steps in your negotiation to identify your objectives, your potential issues, navigate them, and find common ground. Or differently put, consensus. Know what you want from the start. Consider your planning, the scope, the what, the budget, the time, the resources, all of those things in the earlier slide, so that you know realistically where you can compromise. All of this means you need to be super prepared. And make sure, once you've had these discussions, that the 5 components to seal the deal and make a contract have been achieved. And if needs be, get some advice in achieving that. So let me tell you about the team. Now, I know you may think the team, oh, that means the people I've employed. Yes, it means the people you've employed, but not only the people you've employed. The first part of your team and building an effective one is making sure that the right person is in the right seat. That we've constructed our agreements best suited to the outcome we wish to achieve. It could also mean that we ensure that the best person for the job is elected. The best supplier is vetted and chosen to supply. But ultimately, that we are very clear on what we want to see as an outcome. We could also look at partnerships. You'll hear the words strategic partnerships quite a lot if you haven't done so already. This means that we could choose to collaborate, to grow together with another business, complementary, not a competitor, as opposed to saying, hey, let's get married, proverbially, before we've even gotten to know each other and dated. So you need not formalize a partnership right from the start. You could test your concepts, and you could do so in a very safe environment. Insourcing versus outsourcing. In other words, when do you employ someone to perform a particular task versus when do you contract with someone that has an existing infrastructure and able to do the task. Now, it's not always as simple as saying, well, it's about price. Yeah, it's about price, but it's also about the sensitivity of the tasks that need to be performed. And it's also about the capacity. There's no sense in outsourcing a function where your outsourced provider actually, simply put, just doesn't cope with that. Your board. And we may not quite be there to have a board of directors. We may have companies where 1 or 2 people are both shareholders and directors, or maybe it's just you. But someday that may change. And your board essentially can be compared to the crew of a ship, the people who are steering this operation into the deep sea. They are not the people who are working in the engine room. They are the people with the vision, with the foresight, the experience, and therefore a very important part of your team. And lastly, do not forget to see your customers or clients as part of your team. Ultimately, businesses grow and scale that know what their customers want. We do not assume that, and I know many of us are tempted to. That's why we test and we ask questions about our products. How can we improve? And that's why we should be happy if someone tells us when something has not gone very well, complained in other words, as opposed to someone who just tells the whole world that it hasn't gone well. So in terms of going further into the construction now of our proverbial building, our business, I said right at the beginning that your structure is like the foundation. If that is sound, everything that you construct above that, on top of that, is sound. Now, one of the key documents when registering a company that does this is your memorandum of incorporation. You will also have shareholders agreements. Now, those are not part of the foundation necessarily, but they are rather the glue that keeps everything together. The walls, in other words, in many ways, particularly in the start, the weight-bearing walls. Again, with a solid foundation, if you have poorly constructed weight-bearing walls, everything else crumbles as well. So really, this is about financial security, the ability to bring ideas and strategic direction to the table, particularly at the start, and importantly, resources. Later on, this is extended to directors who may very well join the walls, become as important to the organization as the walls. And sometimes they may even be the same people as the shareholders. These are people who ultimately owe their loyalty to the company. Ultimately, not to each other, not to the shareholders, to the well-being of the company. And that's a particular challenge when shareholders and directors are the same people. Why? Because a shareholder is someone who gives you the resources, the ideas, the infrastructure, the money. And obviously, we want to see return on our investment. But a director is someone who makes every decision in the best interest of the business. And then, of course, our board policies and director contracts work together in order to ensure that we pick the best people in steering the ship with us that make the best decisions possible for the business. Now, just to touch on this a little bit further, shareholders ultimately hold the decision-making power in companies. Shareholders can make either ordinary resolutions or special resolutions. In other words, an ordinary decision or a special decision. They have different percentages in order to pass these decisions. 50% for ordinary and 75% for special, which means that our more serious decisions are usually special resolutions. I'll give you a couple of examples shortly. Conversely, directors are one person, one vote. So it's really important for us when we consider and pick our partners that we consider that these are the people that ultimately hold control in our businesses from a decision-making point of view. And the problem is that these people are not regulated by law like directors to act in the best interests of the business. Only when there's an alignment of shared values between you and your partner will this happen naturally. So it's important to pick well and to contract with your shareholders agreement adequately. Okay, so what are special resolutions? It includes to amend the company's constitution or MOI, to merge with another company. Remember, I told you we can collaborate or there could be equity partnership. And then to alienate one of the assets, for example, to sell it, to put it up as security, for example. Ordinary resolutions are, for example, to remove a director, to adopt our strategy and even our budget on an annual basis. So when you hear about corporate governance, there's really only one thing to say about it. It's all about decision making. It's all about understanding which decisions are shareholder decisions. Remember, ordinary or special resolutions, and which ones are day-to-day business decisions made by directors, one person, one vote. So yes, it's important to pick the correct people, but it's also important for you to know in your MOI which decisions fall in which forum, and how do we go about to call meetings and so on. And that is why it's important to have these documents in place and for you to expand your knowledge through one of our courses at Pocket Advisor so that you are able to place the correct people, to contract correctly, and ultimately to understand the documents and the intentions of them as well as possible. Now, the MOI is the document which will give you a guiding compass when it comes to shareholder decisions and director decisions, how to call meetings and so on. But ultimately, it sets out the rights, duties, and responsibilities of all the important role players. It is the one document that really is all-encompassing and only second to the Companies Act. It's one of the most important documents in your business. So to add on from that, your MOI binds the company and its shareholders. The shareholders themselves between one another, the company, each director and prescribed officer, or for example, the company secretary, and all the committees you may form as your business grows. So as you can see, it binds every person that functions in the company. Interestingly, when we dig into this more in depth in our courses, you'll learn that it's much bigger than that. And the Act, working with your MOI, can even ascribe certain rights to external people who are not currently involved in your business. And that is why you may note that many clients, when you do proposals, they ask for a copy of your MOI in order to gauge how you operate and what you do and what don't you do, in simple terms. Directors, and this is important, that's why I want to really repeat this and cement this really, really well in our session today. Directors owe a duty of good faith to the company. They must exercise care, skill, and diligence. They must be accountable for their decisions. So a director is someone who will be judged by the standards set by the Companies Act and the MOI, but will also be judged in the context of their own personal skill and expertise and how they conducted themselves. It's an extremely heavy burden. So many people may not be willing to serve on boards in fear of all the obligations that are imposed on them. And that's okay. That's not the right person for your board if that's the case then. Many of your board members may not actually understand what is expected of them. And again, this is why it's so important, if you are currently a director and a shareholder, or maybe only a director, why it is so important for you to understand exactly what the Act and your company's MOI expects of you. Because if you fall short from performing this expectation, you may be liable personally, and not by a co-director. A shareholder could be the person. Yes, it could be a co-director, but it could also be an external person to the company who feels you've done something or conducted yourself in a way that has prejudiced them. That person can even be an aggrieved employee. Now, of course, these are extreme circumstances, but it is possible. And that is why it's important for us to conduct ourselves worthy of the title. Now, before we get to the end of the session, it is important for us to understand what types of outsourced options exist. Now that we've gone through the foundation, the weight-bearing walls, in other words, our company corporate governance structures in our directors and our shareholders, we need to look at some of the other functions that we may need. Now, I said earlier that we could in or outsource. In other words, employ, or we could outsource to an existing structure. But importantly, the independent contractor is one of the key ways in which we could contract. It's also referred to as the freelancer. For example, we would then tender with someone and subcontract a portion of the work. So we are ultimately responsible that the work gets done, but we do not have all the internal expertise to execute it. And we will then engage with a freelancer on the basis of this agreement. And once the agreement is fulfilled, we go our separate ways. So there's no employment. So it can be linked to another agreement or a particular task. But be careful not to expect from a freelancer what you would expect from an employee. There's no exclusivity. There's no direct control and supervision as you would have with an employee. So things like leave and reporting to work at a particular time, etc., really shouldn't be in this agreement. If it is, it may end you up in the CCMA and your agreement being considered an employment contract when you potentially didn't intend for it to be. A supplier could be anyone who supplies goods or services. Think of your IT provider, or maybe even the person who supplies you with stationery. Agency is a key way in which you are potentially able to expand your reach. Many industries uses it. For example, sales agents, call center agents selling your product as a marketing effort and usually rewarded in commission. Also, medical representatives or reps that sell medical equipment or even pharmaceuticals. Again, it's not an employment relationship. It is an outcome-based, commission-based relationship. The important thing is, though, that to a certain degree, the agent is able to bind or represent or make representations on behalf of the person he or she is acting for. So there is a bit of responsibility that comes with it and should be carefully constructed. A distributor is simply someone who either buys your product and on-sells it, or software, for example, or keeps it at consignment. It's a way in which you are able to reach more customers through people that buy your product and sell it at a predetermined price, or that they keep it and they they on-sell it on a consignment basis without, in other words, purchasing first. And then, of course, the corporate partnership or JV, where we collaborate with another existing business in order to expand our reach. So whatever relationship we have decided to engage, insourced or outsourced. Now, we haven't spoken about employees in our session today, but regardless of whether you are hiring someone as an employee or whether you are outsourcing using one of the mechanisms in the previous slide, it is important for us to ensure that we are clear in the type of relationship we are constructing, that we contract in order to regulate our expectations, to record them transparently so that everyone knows what I expect from you and what you can expect in return from me, as well as any rights, duties, and obligations. It is crucial towards the alignment of expectations and avoiding a situation where expectations are not met, with the end result of disappointment and conflict. It avoids or manages risks. Why? Because with professional guidance and a clear understanding of these relationships from the previous slide and even the corporate governance structures, we are able to place mechanisms in our contracts to say, if this happens, this is how we are going to deal with it. And ultimately, measurable so that we can see, is this contract good for us? Is it good for me? Is it good for you? How do we determine that? What is our metric for that? And that is really the crux of everything that you decide to build in your business, from the discussions and the interactions you are going to have, going into those much more prepared, looking at how you construct the very foundation of your business and which relationships you see as key towards your expansion goals, and ultimately documenting them. And that is ultimately the reasoning behind our courses at Pocket Advisor. To see that we transfer knowledge in a practical way, in the same way as today's session. That we test the transference of the information, and we do that in short videos. Once that is done, for you to download all the agreements required to forge these relationships and many more that I've discussed in our session today. And then, of course, offering you, through the completion of the course, access to me for 4 weeks, wherein we can ensure that each of you attending our courses has gained the most out of the experience in implementing this as best possible in your specific scenario. So actually, you're getting consultation, information, and product for the small fee of joining one of our courses. That brings us to the end of our session. Thank you so much for joining us and for investing your time with us today. We really hope that you've gained some valuable, renewed insights into the legal side of your business. And I really hope that you are ready to take that next step towards really owning the legal side of your business. To that end, I want to take a few more minutes of your time to share our Legal for Startups and Legal for SMEs program with you. I want to share with you what we are able to achieve through it before I go into the details of what you'll get for your investment, not only in time, but in money. If you are going the traditional route of collecting relevant easily digestible legal information, it will take you hours. Or you'll spend it or gain it from an interaction in an attorney's office, which will cost a lot of money and take a lot of time. We've anticipated at least 5 hours or more of your time. That will get you some basic information. From there onwards, you'll spend hundreds of thousands of rands, most likely, to draft a suite of agreements that will follow through from the needs and the information exchanged in the process. So why not either enroll for our Legal for Startups or Legal for SMEs program, where we've packaged critical legal information in an easily digestible, understandable format. 15 to 20 minutes of your time over the course of 60 days, as you can fit it into what we know is a really busy schedule. You will also get a free suite of contract templates, courtesy of Contracts for Biz, so that you are able to implement what you've learned from these pre-recorded videos accessible on our platform. What is more, you can join one of our cohorts. That means you'll be part of a group of like-minded entrepreneurs who will be sharing some of their experiences, and you'll be getting 1 hour in that group with me every week for a period of 1 month, so that we can share some real-life stories and applications, and we can go that next level in a deeper experience towards owning the legal side of your business so that you can be successful. Our Legal for Startups program is ideal for businesses without any employees. It consists of 5 modules, each between 15 and 20 minutes each, and includes over 7 contract templates. Our Legal for SMEs program is ideal for small businesses that do employ staff. Again, it spans over 5 modules, each in length of between 20 and 30 minutes, and over 15 contract templates are included in this program. That brings us to the end of our session today. Thank you so much for joining us. Thank you for taking that first step in investing in the legal side of your business. As a sincere gesture of our gratitude, we would like to offer you an exclusive 500 Rand discount on any of our courses, whether it be our Legal for Startups or Legal for SMEs, or perhaps both. Importantly, this is only redeemable directly at Pocket Advisor and not through any of our affiliates. We really hope to see you in one of our upcoming cohorts. We hope that you'll take another second step towards the legal journey in your business, so that we together can achieve what others managed to achieve in 6 months or longer, and after spending tens of thousands of rands. All you have to do is invest in your ticket. This is less than 4,000 Rand, depending on which of the courses you would like to attend. And of course, do not forget about the exclusive 500 Rand discount. If you have any questions, or if you have any trouble in redeeming your 500 Rand voucher, please contact us at info@pocketadvisor.co.za. Select the dates on which you would like to attend our facilitation sessions, and ensure that you go through the online course material first. Ideally, also download the agreements that are included in each of our courses, so that you can come to the facilitation sessions ready with any industry-specific or business-specific questions. And together, in 30 days, we can have you at a level normally only achievable in 6 months. So what are you waiting for? I hope to see each of you really soon. I know as an entrepreneur myself that time is really of the essence, and it's always in such short supply. So firstly, again, thank you for taking that first step and attending today. And secondly,
That is why our courses are structured so that you have ultimate flexibility, so that you can go through the online course material at your leisure. You have 60 days to do that, and then to join one of our facilitation sessions so that you spend 1 hour, in other words, 4 hours for 30 days, and you achieve what others only do in 6 months or more, and at that expensive price tag. For any further information, do not hesitate to reach out. May your business grow from strength to strength. May you, through your legal compliance journey, ensure that you embrace the next big opportunity that comes your way, whether it is a funding opportunity, a partnership opportunity, or a collaboration opportunity, or even if it's that ideal client. May you be ready for the challenge. Thank you again, and have a great day.